Hello and welcome to everyone who's joined already. We'll just give it a couple of minutes to allow everyone to dial in. So we will start shortly. Hi to everyone that's just joined. We'll be starting very shortly in a couple of minutes. We're just going to allow a little bit more time to let everyone complete their respective dial-in processes. Excellent. Well, let's make a start. So firstly, I'd like to say good afternoon to everyone. My name's Chris Eastham, and I'm delighted to welcome you to this webinar addressing recent developments in international AI regulation. I'm a partner in Field Fisher's Technology Group, and I have the pleasure of chairing our cross-practice working group on artificial intelligence. And in this session, you'll also hear from three of my colleagues. I'm delighted to be joined today by Stefan Zimprick, Tim Van Kennet, and Rem Noormohamed, who, like me, have been closely tracking the development of AI regulation. If you have any questions during the session, do please reserve them, pop them in the box that's provided there, and we'll try our best to answer those at the end. Any that we don't get around to today, we'll follow up on after the session. So there have been a number of newsworthy developments in the last 12 months. So over the course of the next hour, we're going to compare and contrast some of those to give an overview of regulation around the world. And we're also going to talk a little bit about international standards and the industry view, as this is going to be a critical area for development requiring substantial international collaboration. With data being the fuel that powers AI, the interplay between AI and data protection regulation will be crucial. And for that reason, we're going to examine how the recent proposals sit within that context as well. In this session, we'll focus primarily on the latest developments in the UK and the EU, but of course, we also need to keep our eye on what's happening in the wider world. And right now, we're still waiting for a clear picture as to how things will unfold in the US, but based on what I've seen, my feeling is that's going to be taking a more nuanced approach in a similar way to the UK, as we'll come to shortly, rather than the more top-down regulatory approach proposed by Europe. China has also been active recently in establishing its regulatory strategy, and in September it released its latest statement on artificial intelligence ethics. Now, the first three standards will sound familiar to Western readers, being centered around enhancing human well-being, promoting fairness and justice, and protecting privacy and safety. But the principles also refer to ensuring controllability and credibility, strengthening accountability, and improving ethical literacy. Now, of course, concepts such as fairness, justice, and privacy have their roots in the underlying culture, and we must recognize that these may therefore have different meanings in the minds of Chinese legislators to those that we might attribute to those terms ourselves. While the Chinese government has imposed ethical requirements on the development and use of AI, it's arguable, based on the words that they've chosen to use in the statement, that the driving force behind those requirements may be less to do with individual freedoms, public safety, and the protection of personal data, and more about controlling the output and limiting the ability for AI to influence people in what they would call an undesirable way. So the current Chinese strategy is to maintain competitiveness with other major powers, to have a major breakthrough in general AI, to be world leading in some applications, and to expand upon and codify ethical standards in law by 2025, and to become the world's innovation center for AI and grow the core AI industry to a value of 1 trillion yen by 2030. So fairly modest ambitions then from our Chinese counterparts. For the first of our focus sessions, I'd like to hand over to my colleague Stefan, who will provide his perspective on the new European AI regulation. Stefan.
Thank you, Chris, and welcome everybody also from my side. I want to speak about the EU's proposed AI regulation, which has seen the light of the public in April this year, and is meanwhile in the typically complicated EU negotiation process. So what we talk about now may see some changes, but as a general background, we understand that the lawmakers in Brussels and also in the individual member states are really happy with the draft and really happy with their approach, are self-confident, and really like what they did and what they are going to put into practice. It is not something where we expect huge, deeply rooted structural debates. Of course, there will be changes, but these changes, the general structure of the regulation will or is expected to remain as it is now in the draft. If we look at what the EU has in mind, let's start with the term AI system. The regulation starts with that term, and it is important to understand that the EU intends to apply a very, very broad interpretation of the term AI system. These 3 bullet points here are copy-pasted from the law, from its appendix. And while the first 2 bullet points are, well, to be expected, of course, machine learning is something that you would typically associate with AI. The last bullet point, to a certain extent, causes concerns amongst many readers and stakeholders in the market, because it includes search and optimization methods, so very, very standard software development techniques, which would basically result in every modern software being AI within the meaning of the regulation. Chris, if you go forward 1 slide, we will have a look how this AI system then results in a system put into one of 3, maybe 4 buckets. So there's 1 field that the regulation calls, or the draft regulation calls, prohibited AI. And the European lawmakers, they simply do not want such AI to exist or to be put into the market in Europe. The next bucket is high-risk AI, and this is actually the core of the regulation. If you are in the field of high-risk AI, you will see a comprehensive and very far-reaching set of compliance obligations. And we will have a look at these obligations in more detail in a minute. And then there is another bucket, which is headlined with certain AI. That's a very strange law term, I think. It concerns those AI tools which are impersonating humans. So for instance, deepfakes or chatbots. And there we mainly see transparency obligations, and that's about it. Everything what is not covered by these 3 buckets will still be an AI system, but not be at the core of the regulation, and there will not be any further compliance obligation associated with this non-regulated AI. In the next slide, we will have a look into the buckets in more detail. So prohibited AI. The European Union does not want systems that use subliminal techniques beyond a person's consciousness to influence a person's behavior, of course, in a manner that causes harm. That means that these subliminal techniques may be okay if they are not intended to cause harm, which I think is a bit of a strange concept, but well, we will see how this plays out in practice. Similarly, the European Union does not want systems that exploit vulnerabilities, such as age or physical or mental disability. And remarkably, the EU is also against social scoring, and this is probably one of the big differences to what we expect to see in China, where social scoring is already out on the streets, and the ruling party probably sees social scoring as a very important policing tool. There is also a prohibition of real-time remote biometric identification systems, but there are a lot of exemptions here. So law enforcement may not use it to find suspects, but you may use it to find victims. And also you may not use it to find suspects, but if these suspects are suspect of terrorism, there's an exemption that allows you to search for terrorists. So this is a very it's not really a prohibition, I think. My impression is that the scope of the exemptions is so wide that it's actually a permission with certain, roadblocks. Then there's the wide field of high-risk AI, and the concept here is that there is an annex to the regulation that lists these areas and these technologies where the European Union believes it is high risk and should therefore be covered by the regulation. But that list is subject to further development, and the regulation states that the EU Commission can add additional elements and items to that list by means of a delegated act. And That means that you will not always see that the European Parliament has a say in an extension to this list, which is from a legal technique something that may or may not raise certain concerns. If we look at the list in detail, it concerns everything that is critical to infrastructure or to security. So traffic control, traffic monitoring, water supply, heating, electricity, and so on. But also AI that is, for instance, active in automated surgery in a hospital. Then we have access to areas that are believed to be of social relevance or society relevance. So education and vocational training, employment, workers management, access to self-employment. So if you, for instance, develop a tool that supports an employer in selecting those CVs and those applications, which should go to an assessment center or to an interview, and also, of course, at the same time, helps decide who will not be invited to an interview. That is AI that is supposed to be high risk. The same applies to access to essential private and public services and benefits like evaluation of creditworthiness, evaluation of eligibility to public assistance benefits and services. Then there are a couple of bullets here that in the widest sense have to do with law enforcement, and migration, asylum, and border control management is also something that is well related to law enforcement, and also the administration of justice and democratic processes, which mainly concerns elections and court access to courts. You see that these are very high level, all of these points, and it's given that we saw that the term AI system is a very wide one. It's not really clear where this ends or where it starts. For instance, a judge that uses Google search to do some research, is that already something that is an AI system that supports the judge in finding and making a decision? Does it constitute high-risk AI if the judge does so? Okay, the last bucket is certain AI. I already mentioned that this covers systems that are designed to interaction with humans, like emotion recognition systems, but also deep fake tools that are capable of impersonating someone else and faking events on video or audio. Next slide, please. If we look at the compliance obligations, this is a summary of the obligations put on providers of AI system, and you will see at first glance that this is something very comprehensive. We have the obligation to implement risk management systems, to implement data governance rules. We have providers have to ensure that the data has a certain quality, and they need to document everything. So there needs to be a technical documentation that provides proof or establishes that the provider complies with everything of the regulation, everything compliance obligation. And the provider also must keep records of the AI system in operation to be able to show that the operating system always operates in accordance with the regulation. One of the probably most disputed points so far, it's also heavily debated, I understand, in the relevant committees in Brussels, is the question as to what extent human oversight is required and needed. And at the moment, the draft states that there must be human oversight that enables the provider to fully understand the capacities and limitations of the high-risk AI systems and also the monitoring of its operation. And that, of course, means that the more use you make of the options and the possibilities this technology offers, the more problems you will have to really understand what is happening. Deep learning AI, I think one of the remarkable assets of AI is that it trains itself and that there is a result we do not understand, but it's delivering upon these results. And if you overestimate the human oversight requirement here, you may really implement a roadblock here to new developments. Then there's also an obligation to, comply with a system that is already well known. It's called the conformity assessment system. So you have to apply a CE labeling. In order to do that, you have to run a conformity assessment procedure and prepare a conformity declaration. And so this is well known, but how this plays out in practice with respect to an AI system is of course new territory, and we will see how that works out. On the next slide, we will see that it's not only a regulation for the provider, but also importers and users are addressees of certain obligations. An importer basically has to ensure that the actual provider, who is then a non-EU provider, complies with all the obligations that we just saw for providers. And there is also a cooperation obligation with the regulators. And then there are, and that's a bit of a surprise, also certain real legal obligations for users of AI systems. So they are legally obliged to only use an AI system in accordance with the manual, the specification. And they are legally obliged to ensure that the input data is relevant and the right input data for that AI system. And I think this is meant to, in particular, cover those cases where the AI system continues to train upon every data that is fed into the AI system, so that if wrong data is fed into the system, the whole AI system, may be distorted, and the results created by that AI system in the long run may not be accurate anymore. And then there's also obligations to monitor the operation and to retain log files and records if that is something that the AI system is supposed to do. Interestingly, also users are treated as providers, with the consequence that they are under all of these compliance obligations for providers if they market an AI system as a white label system. So if you appear to the public as the one being responsible for putting an AI system into the market, you are treated as the provider, even if it's only a distribution contract underpinning your activity. Okay, next slide, please. Where are we at the moment? So Brussels and the member states, they are very happy. They are continuing to discuss the draft. Several member states have handed in their concerns and change requests, but as I stated at the beginning, it's nothing structural here. Main issues are the definition of the AI system and the high-risk system, the list and Annex 3, level of human oversight, and the delineation of high-risk AI from prohibited AI or non-regulated AI. So there is a concern that the line is blurry also in the direction to the top as well as to the bottom direction. And on the timeline, if things move reasonably quickly, which is to expected here, there is a trilogue in first half of 22, and the bill is to pass in the second half of the year 22, and then we will probably see a 2 years transition period, and then the AI regulation will be in place, and the hope in Brussels is that it will have a similar impact as the GDPR had. And because I now said GDPR, of course, there's an interplay with the GDPR here, because AI often concerns the processing of personal data. And what that means in practice and how to solve the various issues that may pop up with the application of both the GDPR and the AI regulation, Tim van Knaet will now tell you.
Yes, thank you, Stefan. So indeed, GDPR and AI, why is GDPR relevant to AI? Well, if we can move to the next slide, please. It obviously is not always relevant, right? GDPR will only be relevant if the data that the AI system processes contains personal data. And obviously, just by way of reminder, it's not necessarily consumer data that we're talking about, but any information related to an identified or an identifiable individual. But so it could be in in a B2B context as well. And what we see in practice is that many AI systems will be processing at least some personal data. And so that's why GDPR will be relevant. Now, then the big question is obviously, what does it mean? In itself, GDPR doesn't impose specific requirements for AI systems. It claims to be technology agnostic. And so actually most of the GDPR obligations will be similar or actually the same to any other processing activity. So what I would like to do in the next couple of minutes is to briefly touch upon some of the key GDPR aspects for AI systems. And so the first question, the question that you always need to assess first is, of course, whether or not as a provider or as a user of an AI system, whether you are a controller or a processor. And obviously GDPR imposes much more obligations onto controllers and onto processors, so it's very important to know which hat you are wearing. Now, let's take the example of a typical B2B SaaS solution provider. Typically, that provider will be considered as a processor. It will process personal data in the context of its SaaS solution, but that processing is done on behalf of its clients, so clearly a processor situation. Now, if this SaaS solution would include an AI system, then it becomes more complicated because the provider of this SaaS solution / AI system will likely want to reuse its client's personal data to train or retrain the algorithm. Stefan already hinted to that. And so in that case, it's actually not acting on behalf of its client. It's doing this for its own purpose. It wants to improve its own AI system. And so that clearly puts it in the category of the controller. Now, how does that play out in practice? Well, what we see is that it's often a quite difficult commercial discussion for the provider of the AI system to have. It's not easy to convince its customers that it is actually acting as a controller. And so the, let's say, ideal or the compromise approach is to make sure that your contract foresees some sort of a hybrid model, a confirmation that the provider is a processor in the context of the client's use of the AI system, but also allowing some limited controller role for the provider in the context of, let's say, the train the algorithm activity. And obviously, goes without saying in that regard, the more that the provider is able to provide guarantees regarding fair and lawful use, think of data minimization, anonymization, security, well, obviously the easier it should be to convince the client that this controller role is acceptable. Now, moving to the next slide, then the second topic, if the provider and or the user is acting as a controller, obviously it will need to rely on a lawful basis. And if we look at AI systems, there's basically three options that are most relevant. The first two, contractual necessity and consent, they can actually often be relied upon when you are engaging directly with the data subject. So those are quite good and solid lawful grounds. However, as you well know, the threshold for actually both options is quite high. If you look at the guidance from the regulators, contractual necessity, well, the processing must really be necessary to fulfill the contract. So not just nice to have, but necessary. The same with consents. This is probably common knowledge. It really has to be given freely, specifically, on an informed basis and unambiguously. So if that is not the case, then you are in trouble because your lawful basis will not be valid. And so as a result, actually, in many instances, one will have to rely on legitimate interest. And with legitimate interest, obviously, comes the legitimate interest assessment, which you can see on the next slide. It's not mandated as such expressly, explicitly by the GDPR, but for accountability purposes, it's very important that you conduct this LIA. Meaning that as a first step, you have to identify your purpose, and that could be, well, let's say training the AI system, but it could also be the actual use of the AI system in a production environment. So that is a first step. Depending on the purpose, the outcome of your assessment may be very different. So a very crucial element of this assessment. And once you've determined your purpose, you need to assess to which extent your intended processing of personal data is required to achieve your purpose. So the necessity test, which is the second branch of this threefold test. And then once that is done, and typically that's not the most difficult part, comes the most complicated part, which is to balance your legitimate interest against the rights and freedoms of the data subjects. And it's really here where the fairness principle will be extremely important. And I'll address this particular principle in more detail in one of the next slides. Before speaking about it, and actually fairness is part of the data protection principle, so Article 5, you need to comply with the data protection principles as it is the case with any type of data processing. Now, a number of these principles can actually also be found in the proposed AI regulation. Stefan touched upon security of data, cybersecurity. There is accountability in the AI regulation, so there will be some overlap, but there are obviously some specific GDPR principles. I would say purpose limitation and data retention, obviously very important ones in the context of AI, but also very tough to comply with. Ideally, you want to be able to reuse your data for new purposes in the future, and therefore you want to keep as much data as possible, even if you don't need it today. You will know that it's not always easy to reconcile that, let's say, operational need with these two data protection principles. But it's really fairness and transparency that I would like to address in somewhat more detail, and I suggest we first start with fairness. So on the next slide, you can see how EDPB views this principle of fairness. And it says that basically fairness aims at ensuring that data is not processed in a way which is either detrimental, discriminatory, unexpected, or misleading to the data subject. So that's really the philosophy of the fairness principle. And if you think of all the debate about unconscious bias, etc., you can really see how this principle is particularly relevant and important in the context of artificial intelligence. Now, from a GDPR perspective, if you follow the logic of GDPR, it's therefore crucial that fairness is really baked into the design of your AI system. So this goes back to data protection by design, data protection by default. And there are obviously several ways of achieving this, but I think making sure that development teams are diverse and aware of potential issues around fairness is a good start. Impact assessments will be crucial, data protection impact assessments. And there the question is the high risk of the AI regulation the same as a high risk in the context of GDPR? To be honest, we don't know yet, but that will be important to verify on a case-by-case basis. And obviously, most importantly, it's important to ensure that fairness is ensured across the entire life cycle of the AI system. What is fair today may no longer be the case, may no longer be fair tomorrow. So it requires ongoing monitoring. And that leads me to the next key principle, that of transparency. When an AI system processes personal data, both the provider and/or the user will not only need to take into account those AI transparency requirements that Stefan referred to, but also the classic privacy notice requirements. And there is some overlap, but they are not identical. So it will be important to really make sure you comply with both requirements. Obviously, looking at GDPR, the specific attention point is the obligation to provide meaningful information on the logic involved when you are processing data and it involves automated decision making. So Article 22, but only automated decision making that produces legal effects or significantly affects the data subject. So allegedly, we're talking here about high risk AI, but again, is that really the case? The terms don't fully match. But so obviously the key issue there is that it's very difficult to be transparent about this. How does it work? How does this logic work? You have this legal obligation to provide details to individuals, but on the other hand, you don't want to provide too much details because that could be a competitive issue. And more importantly, sometimes it's not even really possible to explain how the AI system is working in the way it is working. So it is a very challenging obligation. It will be a challenging obligation in practice. And so I think by way of conclusion, I think it's clear that both providers and users of AI systems that process personal data will not only need to consider the proposed AI regulation, but also GDPR. And as you can see on this slide, it doesn't stop there. There's many other EU laws that are relevant in the context of AI systems. If we speak about non-personal data, so let's forget about the GDPR part, but really non-personal data, we have the Open Data and Public Sector Information Directive recently updated, which is highly relevant because it obliges public authorities to make public data available, notably in view of developing AI applications. So this will be an important point to bear in mind in the public sector. And we have similarly the Draft Data Governance Act, again a draft, but a draft act which aims to provide a framework to share industrial data between corporations, again in view of facilitating big data analytics and AI. So two very important developments to bear in mind. There is the draft DSA, which also proposes a series of transparency obligations in the context of online services. Think of the situation of using AI in the context of content moderation or online advertisements. Well, there again, the online platforms will have obligations to provide information on how this works. Why am I, as a user, seeing the ads that I'm seeing? What's the logic behind this? So this is what the draft Digital Services Act proposes to address. So a lot of different EU laws in the pipeline. Many have overlapping obligations, unfortunately not identical. So as I pointed out, it will not always be easy to understand what your actual obligations are, but I think it's fair to say that if and when all these laws are adopted, AI will become quite heavily regulated in the EU through many different legal instruments. And so providers and users of AI systems will need to carefully assess their practices in light of these. And with that, I hand over to Chris, I believe.
Lovely, thanks, Tim. So we've heard about the approach proposed for continental Europe, both in respect of the AI regulation. We've also heard how that fits in with the existing GDPR regulations, which clearly apply across Europe, but also still apply in the UK through the UK GDPR. But following Brexit, it's now open to the UK to take a different approach, and that's exactly what is now proposed. So this is the most recent of the developments. On the 22nd of September this year, the UK government published its national AI strategy for delivering on its ambitions to unleash the transformational power of artificial intelligence, as it says, taking a three-pronged approach. So the strategy focuses on making sure that the country as a whole invests in the long-term growth of AI, AI benefiting all sectors and all regions of the economy, and then governing AI effectively by adequate rules which encourage innovation and investment, and also protect the public and the country's fundamental values. Now, the UK's focus on supporting innovation and business is unsurprising, given that over £13.5 billion was invested into 1,400 UK private technology companies in the first half of 2021 alone. Just to put that into perspective, that's more than was invested in Germany and France combined, despite those being the two largest tech markets in the EU. So based on the strength of UK technology, those that I've spoken to in both the public and the private sector expect Britain to be a net exporter of AI in the long run. And these new strategic goals appear to me to be a broader restatement of the UK's previously published objectives, which were announced on the 12th of March by the then Secretary of State for DCMS, Oliver Dowden, MP. But they still encapsulate those aims to grow the UK economy through widespread use of AI technologies, to remain resilient in the face of change through an emphasis on skills, talent, and R&D, very topical at the time it was announced, and ensuring an ethical, safe, and trustworthy development of responsible AI. Now, these broad aims and objectives described are not dissimilar to those put forward by the European regulators. However, whilst the approach suggested by Europe, as you've heard, represents a set of requirements aimed at producers and users of AI as a technology, and is quite specific, the UK government's put forward a proposal aiming for a more nuanced and lighter touch regulation. And the hope is that that will better support innovation, which is the core narrative of the new UK strategy. But what about regulatory reform? Well, whilst we can anticipate some specific proposals for UK regulation in early 2022, when we see the white paper on the regulation and governance of AI, it's unlikely that we're going to see a European-style AI Act. Instead, the UK will look to revisit existing legislation and pursue incremental reform to regulation at the sector level. And I think this was always to be expected. It echoes those recommendations that you'll remember from the House of Lords Select Committee on Artificial Intelligence back in, I think it was March 2018. And it feels to me like we've had a consistent message from UK Gov on this since that time. So by electing to seek rapid progress through incremental reform and by appropriate delegation to existing regulators with the necessary subject matter expertise to ensure assurance of AI systems based on end use, it's possible and the government's hopeful that the UK will steal a march on EU legislators who, history shows us, are at risk of getting bogged down in protracted negotiations for a pan-European regulation. Although, judging from Stefan's comments about the fact that they're quite self-confident in what they've put forward, I guess we'll see how that unfolds. But if we do see a new law introduced in the UK, it's likely to focus on transparency obligations and the like. So looking at those aspects that Tim was talking about. I'd suggest that a new regulator is unlikely. However, because the existing regulators are adequately placed already to enforce rules within their areas of competence, it does remain an open debate, however. There are two areas of general application where we might expect change, and those are data protection and intellectual property. So we've got a consultation open now on copyrights and patents for AI. That opened within the last couple of weeks, I think, and that ends in January. And we've had the consultation on data privacy, which they call Data A New Direction, and that actually closes at the end of this week. So knowing that the interplay between AI and data protection is going to be central to reform, as well as one of the earliest aspects to be implemented in UK law, we can look to certain aspects of the proposed changes in that consultation to give some more clues as to the likely direction of travel when it comes to AI generally. So on the 10th of September, and following on from the UK's 10 tech priorities, which were announced on the 12th of March, UK Gov announced a 10-week consultation on reforming the UK's data protection framework. And it contemplates deviation from a GDPR-matched approach post-Brexit. And as I mentioned, that ends on Friday. So what deviations might we see? Well, the proposed reforms reflect the government's drive to operate that pro-growth and innovation-friendly regime that I was talking about, whilst maintaining high data protection standards and, most crucially, adequacy status from a European perspective. So their aim is to boost innovation and economic growth by reducing what they describe as unnecessary barriers that currently exist under the Data Protection Act 2018 and the UK GDPR as introduced into UK law. The government's keen to emphasise that whilst it intends to retain the technology neutral approach of GDPR and avoid allowing technology-driven harms, it also seeks to ensure regulation doesn't impede what it calls data-driven innovation. So in contrast to the EU's focus on individual control, irrespective of whether the processing is good or bad, the general direction the UK now appears to be tilting towards is to take that balance away from individual rights and towards reducing the administrative burden on businesses to comply with regulations in order to encourage good use of data, specifically when it comes to artificial intelligence. Tim also talks about fairness, and that's a substantial part of the UK's strategy. And that consultation, that data consultation, they've got real concerns about what fairness really means for AI, particularly when that term is used in the data protection context, as well as a lack of clarity regarding the ICO's regulatory reach. So we've heard what it means from a European perspective. Some of the guidance is still valid for the UK in law, but the UK view is that we can think about fairness as falling within one of three aspects, and those, as highlighted on the slide, are fair data use, procedural fairness, and outcome fairness. So fair data use, the first of these three, falls firmly within the scope of the data protection regulation. We've been living with the regime for many years now, and the concepts are reasonably well understood. There's a surfeit of guidance, but the problem is we've got that surfeit of opinion from different stakeholders, and we might therefore expect new consolidated guidance to clarify what constitutes fair data use when it comes to AI. One example reflected in the findings from the Centre for Data Ethics and Innovation suggested a lack of understanding around how to use personal data, including sensitive personal data, for mitigating bias in AI, and that this is paralyzing for organizations. Well, the necessity of using personal data for bias detection and mitigation in AI systems has been recognized by the ICO, and to combat this, the government's proposed to permit processing personal data for those purposes as a legitimate interest for which the balancing test that Tim described isn't required. And in some cases, that would extend to special category personal data as well. Notably, that reflects the approach that's proposed by the EU in its draft regulation. Procedural fairness is a more complex question. As it stands under the current legal framework, there are provisions on automated decision-making, including profile, and we've talked specifically about Article 22 of GDPR and the UK GDPR, where data subjects have the right to not be subject to solely automated decision-making processes where they have significant effects. Now, whilst the consultation contemplates the removal of Article 22 as recommended by the Task Force on Innovation, Growth and Regulatory Reform, or TIGA, as I like to think of them, this might be the topic of separate regulation if Article 22 is in fact removed from UK GDPR. However, I think that's relatively unlikely. It's more likely, to my mind, that UK Gov will be looking for evidence of a problem in practice and then for ways of being more definitive about it, either by amending Article 22 or through consolidated guidance to ensure that innovation continues to be supported. And then as to outcome fairness, the consultation suggests that horizontal or sector-specific laws and the associated regulators might be the best way to deal with fairness of outcome in the context of AI systems. And that's reflective of the approach that's set out in the strategy more broadly. So, as acknowledged by the recent consultation, the multiple and sometimes conflicting definitions around artificial intelligence can cause confusion. Now, from a European perspective, it's proposed that AI will be defined very broadly, a software that can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions, influencing the environments it interacts with, and that's developed using a defined set of approaches, which Stefan talked about earlier. Now, in the UK, we don't have that degree of clarity in the law, and a number of definitions exist in various contexts. For the purposes of the consultation, artificial intelligence was defined as the use of digital technology to create systems capable of performing tasks commonly thought to require intelligence, which doesn't really take us forward, does it, from a legal perspective, unless we can resolve grand philosophical questions about the nature of intelligence. However, there was a recognition that the state of AI is constantly evolving. Now, if we look to other UK legislative instruments, such as the draft regulations proposed to support the new National Security and Investment Act 2021, they refer to AI as being technology enabling the programming or training of a device or software to perceive environments through the use of data, interpret data using automated processing designed to approximate cognitive abilities, and make recommendations, predictions, or decisions with a view to achieving a specific objective. Again, whilst that might be suitable for the purposes of that specific act, I think it's unlikely that this definition would be adopted for English law in general. I think the concept of AI is sufficiently nebulous that we're more likely to see nuanced definitions focusing on the attributes of AI that are relevant for the purposes of specific legislation, rather than a general definition that can be applied across the law. However, that does still remain an open question. I'm not going to put a lot of money on it, but I think if I were going to put any money on it, I'd bet that there's going to be a number of nuanced definitions. So AI assurance and standards are also a key feature of the UK strategy, and for good reason. The UK government has recognised the importance of securing interoperability with all key markets for the purpose of supporting international trade and economic growth. And by gathering inputs from UK stakeholders and communicating those on the global stage, the AI standards hub described in the strategy is going to be crucial. By contributing to and influencing the development of global standards, the government proposes to achieve interoperability and minimise the costs of regulatory compliance, but without having to seek parity in the regulatory approach. This isn't without risk, however, because it depends on how much influence the UK can wield in those discussions, the timescales for establishing the standards, and still ensuring that those standards allow compliance with all relevant regulatory regimes worldwide. The strategy also talks about the publication of an AI assurance roadmap, and that is likely to aim to bring together techniques to manage risk and compliance from various contexts, such as impact assessments, audits, independent verification against standards. And the idea is that it provides a toolkit for the regulators, so FCA, Ofcom, MHRA, whoever it happens to be, to select from when they're looking at what degree of verification of conformance is appropriate to the specific context they're looking at. And providing that single toolkit together with the collaboration between regulators that they're looking to improve upon, that could lead to a more consistent approach potentially, which would then reduce the regulatory burden on AI providers. So just to conclude on the UK strategy then, whilst participating in multilateral discussions on the world stage to shape approaches to AI governance, the UK government is clearly intent on taking a different path to Europe, for example, and is seeking to gain a competitive advantage on the global stage by taking what it considers to be a more nuanced and, crucially, a business-friendly approach to AI regulation. On the national scale, it's going to be helpful to startups and smaller businesses focused on the UK market, but recognizing that national boundaries are less relevant when it comes to digital products and services, international businesses and those looking to scale, there may be increased costs for those because they've got to ensure compliance across borders, and there's going to be, the greater the divergence between those regulatory environments. My view remains that all businesses will benefit from interoperability. And thankfully, based on what I've read, I'm comforted that the UK government appears to share my desire for a global AI ecosystem, promoting innovation and responsible development. Highlighting the importance of securing interoperability through collaboration on the global stage segues us neatly onto the next section, I'm pleased to say. And my partner, Rem, is closely involved in various international standards bodies. So I'd like him to invite him to talk briefly about those structures and the emerging standards in this area. So Rem, over to you.
Chris, many thanks for that. I'm just conscious of time. We've got about 7 minutes and we would like to take some questions. So I will effectively trot through this. It's essentially a high-level overview of the role and function of standards and how they come to be and how participation drives the sum total forward in terms of the AI space. So look, AI isn't new. We've been dealing in technology involving artificial intelligence since the 1950s, and during that time we've seen certain winters and summers of advancement in AI. So whilst it still remains after all these years an emergent technology, what we have seen of late, which is I guess what's making it very fashionable and a huge amount of excitement, is we've seen a huge amount of computing power processing, and whether that's at the edge or in the cloud, it's driving the change and the need for greater standards. There's a huge amount of participation at nation states, pan-European and international stage in terms of initiatives. So you have the OECD's reports and findings and initiatives, as well as United Nations. But what we've got effectively is a jockeying and a positioning for not only member states, but effectively corporates as well. So on the one hand, you have the emergence of draft legislation, which the chats have been talking about, and we can see the need for broader regulation and governance through artificial intelligence. So that tends to look at the sort of the societal and the governmental perspective and the sort of super-governmental perspective. But in terms of corporates, what we are seeing is a huge amount of investment being ploughed into research and development to drive new products, service lines for AI systems in many sectors, and clearly within the automotive sector with connected and autonomous vehicles, we're seeing a huge amount of movement there. The health sector is a huge beneficiary of the use of AI, and increasingly within the aeronautics space, we're seeing quite a lot of developments there. So these are just a few that are in motion. Clearly what we've got is a series of competitive positions being taken to drive corporate imperatives, clearly first mover advantage, growing new and existing markets, accounting, and driving new revenue channels to secure clearly the return on investment that's coming from the huge funding that's been made available to the corporates. So that kind of sets the scene between the players, if you like, the stakeholders. And what does that mean? So, well, within the benefits of within standardization, the benefits are quite clear. If you can bring together all the technical experts in one place, and those technical experts are in a position where they can seek to challenge, but also be challenged by national policies and those set out at the international platform, the OECD and the UN's, the world, but also by the corporate drivers, the corporate positions for what's good for them. What you've got is an environment where actually a lot of those issues can be thrashed through, and given the fact that the standardization process is a consensual process, it operates through very much an inclusive approach, where transparency and a democratized system of standards development is very much the basis upon which it moves forward. It is a multi-stage environment, and as you can imagine, with the degree of stakeholders and multi-stakeholders, there are quite a lot of views and interests to take into account, and particularly at sort of the nation states level, there's a lot of activity being generated, unsurprisingly, through China. Now, clearly, by adopting this consensus model, what we get to see is a promotion of trust and confidence at an international stage. And what it does offer is stakeholders a sense of ownership through their contribution, but also willingness to promote and use the standards. Clearly, the advantages of standardized models include developing best practices, as well as identifying common risk issues and approaches to mitigate them through better governance, assurance, as we've heard, compliance, and ultimately accountability, whether that's at a state level or at a corporate level. From a technical perspective, as Chris has mentioned, standards create the building blocks, and the building blocks for achieving what is really critical at a technical level, which is interoperability between AI systems and clearly at scale. We've also seen the use of standards to complement as well as supplement policies, regulations, and legislation. And this is very much the approach that the the European Union takes, which is for the benefit societally as well as in terms of member state. It is really important that the objectives that legislation, policy and principles, as well as the values of the EU, are enshrined not only in law, but very much through the application of standards. So there is a dovetailing that the European position adopts. So effectively, the standards and standardization environment is effectively there to set ground rules to help reduce the risk and barriers to international development, innovation, market competition for driving future capable AI systems. Chris, next page, please. So in terms of who the players are, or before I get on to who they are, one thing that I haven't got time to talk about here is the emergence of open standards, and as well as those from what are known as SDOs, the Standards Development Organizations. If we just focus with the remaining time very quickly on the SDOs, we can see that some of the international agencies are well known. For example, the International Organization for Standardization and the International Electrotechnical Commission, as well as the ITU, the International Telecommunications Unit, which forms part of the UN's mandate. The ISO and the IEC have formed a joint technical committee to look specifically at artificial intelligence, and that's known as the ICO, IEC, it rolls off the tongue, JTC1, SC42, that's subcommittee 42, and they really, or we really focus on driving all the various aspects associated with artificial intelligence, from AI systems engineering to standardization roadmaps, liaising with different committees and other institutions to make sure there is a consistency amongst the SDOs as well as beyond the SDOs. So you can see there's the whole load. I think there's something like 12 different subgroups that come into play. At the European level, what you have are the key players, which is CEN, CENELEC, and ETSI. And again, CEN and CENELEC, the process there has been adopted to follow really the developments in the law. So the latest Artificial Intelligence Act and the relationships that the standardization will bear will be very closely matched. And then very quickly in the UK, we have BSI. Now, in relation to CEN, CENELEC and ISO, IEC, there is effectively a mirror committee. So Artificial Intelligence Group ART 1001 mirrors and discusses those wider implications for the UK. So clearly the UK will be jockeying for its policies and priorities strategically, and it will have those discussions with the wider group from the different stakeholders. I'm just very conscious of time. Effectively, what I will finish on, Chris, if we can just double click to the very last page. So just as an example of what the subcommittee 42 at the ISO have been working on. So there have been 9 published AI standards, and again, there's a link to the bottom of the page, so don't worry about trying to find out all about that in the next 10 seconds. You can certainly have a look there, and there are 23 standards currently in development, so there is quite a lot afoot. Standards aren't quick, they do take some time, but again, as you can imagine, getting a consensus model to operate amongst all the stakeholders is never a quick process, but the key thing is that it gets done properly, and again, it's refreshed as required from time to time. I'm going to stop there, conscious that we are slightly over by 2 minutes, but it would be good to see if we've got some questions, Chris.
Yeah, I think we do have a few questions. I think the best bet is to follow up with those questions afterwards. We're very happy to do that. If you do have a couple of minutes to bear with us, I do have a couple of final conclusions for businesses operating in this space, and you might be wondering where we go next. But completely understand if you do have to drop if you have another appointment now. And apologies for running over slightly. So where does it leave businesses operating in the space? Well, firstly, we've got an emerging degree of clarity around what's going to be expected on both the national and international level when it comes to compliance. We're already in a position now to advise our clients as to whether they might be caught by particular regulatory regimes and what those implications might be. For me, it feels a little bit like did in 2016 prior to GDPR, we know that rules are coming and that businesses need to comply or face very substantial fines, even higher than under GDPR actually. And last time, far too many organisations left it too late, resulting in that panic and the compliance activity at the last minute and increased costs as a consequence. So my suggestion would be to start thinking now about what's required for compliance and planning ahead to have measures in place in a timely manner. What do I mean by that? Well, I'd begin by understanding the scope of your development and use of relevant technologies, both now and in the future, what you're going to be developing. And of course, that means having the right governance structures and processes in place. It also means looking at your organizational values and understanding how the use of AI and the associated digital ethics considerations fit into that. And I'd be looking at each use case of AI and making sure that I had the right transparency measures in place, particularly including explainability statements. I'd also be looking at the different business lines and the current anticipated use cases for AI, and I'd be measuring those against the threshold test for high-risk AI. Regulatory sandboxes are planned to provide a controlled environment for development, testing and validation of new AI systems for a limited time before their placement on the market. It may be appropriate to get involved in those if your business is going to get caught by the new AI Act in Europe. And then the other thing I'd be looking at is influencing the direction of travel in line with the business's overall strategic objectives. And I've mentioned 2 consultation processes today, as well as engaging with legislators and regulators early on whilst they're still forming their views. The Commission and Member States will encourage and facilitate codes of conduct intended to foster the voluntary application of controls. So getting involved in those is probably a smart move. It's also worth noting that there's going to be common data spaces established by the Commission as part of its data strategy, giving access to high quality trusted data for the development of new products. And lastly, bear in mind the effect of Article 83 of the draft regulation. If an AI component is placed on the market early enough before the new law comes in, then it will be treated, it won't be caught by the new regulation. So there's a timing aspect to this as well. And lastly, we've already begun helping clients with AI strategy and compliance, and we'd be very happy, of course, to have a conversation with any of you as you start your own preparations. So with apologies for the 5-minute overrun, that does bring the prepared part of the session to a close. There were a number of questions. We will follow up on those after the session. So it just remains for me to say on behalf of myself and the panelists, thanks very much for everyone for joining today, and I hope that you enjoy the rest of your respective days. Thank you very much.
Thank you.
Thank you.
Thanks, everyone.